17.
My lord, please let us know what is the appearing. Shaunak Bhattacharya.
Since I'm not inclined to take up this matter,
Your Lordship, this is my application, which I have filed for praying for expeditious hearing of a matter which is pending before the civil judge at Barasat. I'm the defendant in that matter. It was filed in the year 2011.
what is the nature of the proceeding?
Your Lordship, they prayed for permanent injunction restraining the defendant to erect a tower and make any construction on his property which is purchased by the sale
The
deed.
application under Article 227 of the Constitution of India.
One announcement in the bar, my lord. Lordship is going to take urgent matter of Justice Chondo, my lord. There's an announcement, my lord, in the bar.
There's been executive.
On basis of that, I am mentioning one matter, if my lord allows.
Mr. Chatterjee, please come at 12.
My lord.
দেখে নিন ওটা একটু ইয়েতে ওয়েবসাইটে দেখ Yes, call the next matter.
19.
My lord, in this matter, I am for the petitioner led by Mr. Kosto Bakshi. He is before courtroom number 35. On his behalf, can this matter be passed over for just 5 minutes, man? And otherwise, my lord, this is my application for expeditious disposal, my lord, of a suit for eviction of a licensee and khas possession. My lord, the matter was initiated on the 6th day of February 2013, and my lord, till date,
It's at the argument stage.
yeah, my lord, the difficulty is this is the second time the proceeding has been gone for the argument stage, and now, my lord, on the last occasion, that is,
It was for the argument of the defendant.
my lord, this kindly observe the observation of the learned court below, that is from the order dated 25th January 2019. My lord, the learned court had observed that the defendant are in a habit of dropping the proceeding. Furthermore, my lord, there previously,
All right, 23rd of April it has been fixed for argument.
yes, ma'am. My
This
lord, a expeditious disposal order was previously also passed by this honorable court, my lord. So, my lord, if that be taken into consideration, if a time frame could be provided, my lord.
this application
But in this matter, my lord, I beg to appear for the petition, my lord.
Yes, Mr. Bakshi.
My lord, I beg to appear for the petitioner in this matter, my lord. There's an application for an expeditious disposal.
Yes, yes,
This
it's argument stage. I am directing the arguments to be concluded within a certain time.
My lord, my lord, my lord, my lord.
The learned advocate.
My lord, I am appearing on behalf of the petitioner. My lord. This is the expeditious disposal of the title suit, my lord, pending before the learned court, Civil Judge Senior Division at Alipur. And this is a suit for declaration and injunction, my lord.
Benjamin Mallard, I am appearing on behalf of the petition. I have come up challenging an order dated 12th of September 2024, passed by the Learned Civil Judge Junior Division Third Court in eviction suit number 47 of 2011. My lord, the petitioner before your lordship is one of the defendants in the said suit. He is in possession of the suit property. He filed an application under Order 39, Rule 7 for local inspection of the suit property, and for repairing the suit property at his own cost. Now, my lord, that was turned down by the learned civil judge.
Earlier, you also filed an application for
My lord,
repairing.
I'm just,
Where is that?
my lord, that application, my lord, your lordship will come to page 40. Page 35. I beg your lordship.
Yes.
My application was previously allowed in 2016.
Did you undertake the repairs?
My lord, no.
Why?
My lord, I had some financial difficulty. That is the admitted position.
What is the stage of the suit?
My lord, the suit is currently pending for examination of the witness on behalf of the defendant.
Defendant.
On behalf of the defendant.
So, defendant, which DW?
DW2, my lord. According
How
to
many
my-
more witnesses you will adduce?
My lord, my instructions are possibly one or two.
One or two.
One.
Complete that by the end of May. I'm directing. Don't spend money because since 2016 you have not repaired.
Difficulty is your lordship will just look at the photographs once.
Maybe. তারপরে লিখুন
The petitioner,
I got to
tablet has
opposite
been
party.
lodged, my lord. I have already served the copy.
I have
This is the affidavit of
Yes,
service.
yes. What
I
is
have
this
been
matter?
My lord, my application under order 8 rule 3A, my lord, of has been, my lord, dismissed. If your lordship kindly see, my lord, the impugned order. Order number 46. My lord, the plaintiffs have raised strong objection and have pointed out that in the show cause petition filed on.
What are the documents? Where is your application under order 8 rule 1?
Yes, my lord. It is that, my lord, page 52.
52. Why you did not produce it earlier?
My lord,
Twice.
along with the, my lord, written statement, it has not been, my lord, annexed. But, my lord, they have filed an application after that, and, my lord, I have already served all of the documents to them. And,
You
my
have
lord,
served all
the
the
court noted it.
documents to them.
Yes, my lord, and the court also noted that.
Yes, Mr. Rai.
This is not correct. Kindly come to page 40. Page 40.
40, yes.
We made one application that since in the written statement, you have in para 9, you have referred to certain documents. You please produce those documents. Kindly come to the order passed on 20th of April. Today speaks for the ends of justice. The application dated 22nd of February 22 under section 151 is hereby allowed. Since the same would not cause any prejudice or injury to the other side, the plaintiff is directed to inspect the authenticated documents mentioned in paragraph 9 of the written statement, and the defendants are hereby directed to.
They did not produce that.
Then what happened?
My lord,
Kindly see.
after, my lord, the
I-
order next after.
Please allow me. Then kindly come to page 46. We made one application that his defense against be struck out because non-compliance of the court's order. Kindly come to page 46, order number 24. The defendant was directed to produce cause discovery and inspection of certain documents, but the defendants filed a list of documents under a free sheet received by the plaintiff, which do not contain the relevant documents as per paragraph 9 of the written statement submitted by the defendant. This should be construed as the non-compliance of the court's previous
Yes,
order.
what happened? Stokos thereafter?
Because they filed subsequently.
Stokos was accepted.
Focus was accepted, but there is no whisper about the documents. Thereafter, my lord, they filed the examination in chief. Kindly come to the application. There is no whisper why it was not produced. And in the written statement, there is no list of documents. Nothing. So this is the written statement. Kindly.
Paragraph 9, some documents have been referred.
No document. Kindly see that rent bill has been issued in my name. Nothing more.
So they let them produce only those. That is what they are trying to.
We do not know, my lord, what are those documents, because my evidence is.
What are the documents you want to produce?
My evidence is over.
Why have you stated that?
Well, just kindly come to page 41.
No, in the
But
written
the
statement,
order-
no whisper, no list
The
of
order they have
documents.
Show
just
me what are the documents. Where is that list which you want to produce?
Malas, the affidavit in chief, Malas, I have already annexed. Malas, page number, Malas, 49.
No, you have not specified any documents.
Nothing
What are
in
the
written
documents?
statement.
Malas, the written statement, there is no document that has been annexed. In affidavit in chief, we have said,
What are the documents? You have not specified.
Malas, page number 49, if your lordship kindly comes.
Yes, page number 49.
Page number 50.
Yes.
This is, Malad, I am tendering the, Malad, trade license. This is
Yes, trade license, no
trade
problem.
license, rent receipt, being number such and such. And Malad, 2 numbers of rent control deposit chala for the month of such and such.
No.
And Aadhaar card.
In the application, you have not stated anything.
Nothing.
Show me in the application you have stated which are the documents which you want to produce.
Malas, these are the, Malad, documents.
Nothing has been
Affidavit-
stated.
Malas, affidavit-
Where? What are the documents?
Nothing
You have not stated that.
I have first, Malas, filed the affidavit in chief. Thereafter, Malas, I filed the, Malas, application under order 8, rule 138. That I want to produce those documents, kindly grant us leave.
No, order.
Why did you not produce it earlier?
Malas, it has not been produced.
You are the defendant.
Malas, yes.
So they did not have the opportunity in the evidence.
My
to deal with
evidence is
those.
over.
Malas, if your lordship kindly comes to Malas.
Rightly rejected.
Malas, page 40 only comes once. Page
Of
40.
the lacuna, and
Plus-
the document was subsequently prepared.
Malas, page
No
40.
list of documents, nothing.
Page 40, Malas, the order that has been showed by my learned friend. The next order. Plaintiff and defendant files Hajira. Defendant are files a list of documents which is received by the plaintiff.
No. Page.
Page 40.
Yes, page 40 is the order.
Yes, Malas, the order number 22.
Yes.
plaintiff and defendant files Hajira, defendant files a list of document which is received by the plaintiff.
Where is the list? I want to see the list.
The list we have misplaced. We have already Manoj paid for
Document,
certified copy of the
nothing.
document, certified copy of the Manoj list.
This is manufactured.
Manoj, they refuse to Manoj give us a certified copy because they said there is a rule that they cannot provide certified copy of the list of document. That is
One
why.
order
Manoj,
eight,
if they can
rule
produce
1A.
Manoj, they have that in their capacity.
No.
There also you have not produced any list. Nothing.
Manoj, I have the list, Manoj. If your lordship says
At
that
this
has not
stage,
been annexed with the
No,
Manoj.
not here, not before the court trial judge, you have not.
Yes,
produced
Manoj.
any list.
The trial judge, it was there. Not.
Where? Show
Yes.
me.
This is the Manoj list of documents.
Show it to Mr. Rai.
Manoj, this is Manoj already served to them.
Yes, Mr. Rai. See this. 8 adiantu.
This we have received. The problem is, my lord,
This you have received.
the problem is,
So I can direct them to produce this.
kindly allow me, my lord. In the written order A, rule A has some preconditions. Sir, kindly take up the. That has not been complied with. Had it been complied with, documents, I am the last person to oppose. But there are certain circumstances.
Yes.
But the defendant, kindly see, my lord. Where the defendant bases his defense upon a document or relies upon any document in his possession or power in support of his defense or claim for set-off or counterclaim, he shall enter such document in a list and shall produce it in court when the written statement is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the written statement. I have placed the written statement before your lordship. There is nothing. No list of document, no document annex, nothing. We have, under these circumstances,
And rule 3, sub-rule 3
Leave-
creates a
leave-
bar with the leave.
with the leave, but they have to explain there is nothing in the application. Kindly come to.
Now
page
you have got
52.
this, you will be producing only those documents.
Yes, my lord. Only
But
the,
Mr. Rai,
Manoj, only the
Then
list
what
of
about
documents I have.
my evidence? I have already
that I will give you liberty for that.
and I have to pray for cancellation of those documents. It will delay the trial because it is my specific
That
case.
steps
We are
you can
suffering an
take.
order of injunction.
Mr. Rai, you can take those steps. I will give you liberty to recall your weaknesses with regard to those.
But they must specify the reason, my lord, why it was not produced, even after so cause. Kindly come to page 52, para 3. Nothing is stated.
I appreciate.
Plaintiffs have filed one application under section 151 CPC praying for necessary.
Mr. Rai, the difficulty is if this is rejected, they will have another opportunity to file giving that list. This list they will give. It will further delay.
No question of delay, my lord. I am not trying to cause any delay. But kindly see, when I am making the application before a court of law, there must be some ground. Because at the initial stage in the written statement, nothing is there. When the court directed them not produce, then we made one application under order 11 to 21 for striking out the defense. At that time also not produced. At this, we adduced evidence. At this stage, they are coming. There is no explanation why the documents were not produced. And as per the
Manoj, I am disputing that. The moment they filed their application, we have Manoj served all the documents, and I will only.
Why you did not produce it earlier?
No
What is the reason?
explanation. No, nothing has been
Manoj,
stated.
they have filed an application
As
in
per direction of
2022,
this learned
and I am Manoj served the copies to them on
No, no, no.
2022
Why
itself.
you have not
And Manoj, I've
produced
said,
Why you did not produce
this
it earlier?
particular document?
because they have filed the
You have
application.
not cited any reasons in this
No,
application.
nothing,
The court
nothing.
said that Manoj, the
Granting of leave is not automatic.
Manoj, the court said that Manoj, that they don't have these documents. I don't have served them the documents. That is why Manoj, I've said I have already served those documents. That has not been annexed. Manoj, that
You
is
have to
not.
file those documents along with the written statement.
Manoj,
You have not done that.
yes, Manoj.
Why you did not file that along with your written statement?
Manoj,
No list of
Manoj,
documents.
that is why Manoj order 8 rule 1. Right?
No.
That is why Manoj order 8
Leave.
1 and 3.
So leave is subject to satisfaction. Why you did not? It's not automatic. At any point of time, we will come where evidence has been closed.
Yes, Manoj, but we have already
Partition
served those
is
documents
sub
before
rule
the evidence of
You
the
go there, file an application explaining the delay.
Manoj, there is a judgment of the Supreme Court if your lordship kindly
What?
considers. The very recent judgment of the Supreme
Reported or unreported?
Court. Reported, but we have Manoj, this is reported.
To be
Well,
reported. Kindly
I
give
am
me a
giving-
copy.
I'm giving a your lordship. Paragraph 2, my lord, this appeal is directed against, my lord, the last three lines, appellants challenging refusal to entertain an application under order date rule 13A of the Code of Civil Procedure 1908, seeking leave of the court to produce additional document. Paragraph 8. Subrule 3 as quoted above provides a second opportunity to the defendant to produce the documents which ought to have been produced in the court along with the written statement with the leave of the court. The discretion conferred upon the court to grant such leave is to be exercised judicially where there is no straitjacket formula. This leave can be granted by the court on a good cause being shown by the defendant. It is often said that procedure is the handmaid of justice. Procedural and technical hurdles shall not be allowed to come in the way of the court while doing substantial justice. If the procedural violation does not seriously cause prejudice to the adversary party, court must lean towards doing substantial justice rather than relying upon procedural and technical violations. We should not forget that
Where
the
have you
fact-
stated these reasons? These reasons were there, that they have traced out very recently. Where is that?
Manoj, we have said, Manoj, we have already served those
nothing has been
documents.
stated.
Manoj,
Show me from your state, from your application,
Yes.
that was your ground. This was the ground where those documents were traced subsequently.
Manoj, very
And
well.
what is the suit for?
Manoj, the suit
For declaration injunction, it is a
Yes.
joint tenancy.
What is the declaration for?
Declaration that it
Page
is a
20.
joint tenancy.
Manoj, page 23.
I have made the landlord a party not to issue rent bill
Page
in the name of
23.
the defendant.
So he is the landlord,
No.
Manoj, I am
Landlord is a pro forma defendant.
Manoj, we are
pro
brothers.
forma defendant.
Yes, subsequently the document has been procured.
Manoj, we are
The pro
brothers.
forma defendant and subsisting order of injunction is there. I do not know, my lord, how the document has been issued.
Manoj,
This can be manufactured at any time.
Manoj, we have already served those documents
No,
to them
no.
in 2022.
Then why you have suffered this?
And
so
these
much?
are all the public documents, the rain control challans, my lord.
This application under Article
My lord, Malas
if
they
you
want
want,
the
there are
authenticated.
two ways. One is you can give a proper explanation. If you want me to go into this, I will go into this
Malas
business.
their application is to malas serve copy. Malas they that is why malas we have served
All
copy.
right. I will deal with those.
And malas that is malas I have already served those documents. That is why malas show cause petition, if your lordship kindly sees
Yes.
page 47. The defendant number 1 have already served copy upon the learned advocate for the plaintiff upon which
What copy? Xerox copy, illegible copy.
malas Xerox copy I have no Xerox copy as
Where are the original documents?
that will be produced during the malas examination. I will tender those documents original. And malas because rent control challans and malas the Aadhaar card
Where is your affidavit in chief?
49.
Mr. Rai, even if this is not produced, they can at the time of evidence produce this.
But the problem is kindly come to page.
All right, I'm coming after 5 minutes. Yes, Mr. Chatterjee. Yes.
Regarding application number 1213, my lord, of lordships, this, my lord.
What is the grave urgency? You cannot wait.
Urgencies, my lord, there is an order, my lord, of demolition, but still they are continuing the construction, illegal construction, the respondent, private respondent.
That can wait for 1 day. So Chatterjee, that can wait for 1 day.
Right.
It will be, if there is an order of demolition, they are continuing, that cannot be an urgent. Then wait for 1 day. Because other side is to be put on notice, they have to be served.
I have informed the municipality, my lord.
Private party is there who is constructing. Because it's appearing in the list and can wait for 1 day. It's not that urgent.
I have tried my
Maybe some amount of construction, if it is demolished, today's construction will also be demolished.
Let me
Yes,
conclude, my lord. Kindly come to page.
give me a minute.
Kindly come to page 40.
Give me a minute.
Yes.
Yes,
Kindly come to page 40, the first order, 20th of April. Penultimate paragraph. Was discovery and inspection. So no inspection, and this is the document. Kindly see the Xerox copy placed, not the original. Kindly see how it is manufactured subsequently. At a glance, I will place before your lordship.
no, Mr. Rai, you can take all objections
Yes.
when it is produced.
Yes.
I'm not there to decide on the genuinity of these documents
Yes.
because now they have filed their affidavit in chief.
Yes.
Now, along with the affidavit in chief, they have filed these documents, the copies of these documents, copies of these documents. That copy of the affidavit in chief has been, along with those documents, have been supplied to you. But mere production of those copies of the documents does not mean that automatically it is proof. Those will be, whether those will be marked as exhibits or not, that will be subject to the orders of the court. You raise objection with regard to.
Kindly make it clear.
Has to be, that is the law.
Yes.
That is the law.
And my further submission, kindly record this, that there is no proper explanation in page 52, para 3, why it was not produced, why the document was not.
Even if, Mr. Rai, even if
Yes.
they do not produce, that leave is rejected, they can produce, they have already filed. That cannot be shut out.
Subject to compliance of order rule 1A, sub rule 1. If that is complied, there is no list of documents. The problem is, my lord, in the plain, if there is no list of documents, that
I appreciate that, but along with the affidavit in chief, they have filed these documents, copy has been served. So, but automatically it cannot be marked as an exhibit. You
Yes,
take
yes.
all points.
Yes, yes.
That is the law.
Kindly observe this.
What is the, what to be observed? That is the law.
No.
Mr. Rai, kindly come to the order 18. That is the law.
There is a procedure, my lord. The trial court will say it is marked with objection. But once.
No. Can it be? You are there.
Yes,
So, you will not allow that.
certainly. not.
Kindly come to order 18, rule 4.
Yes. Recording of evidence, in every case, the examination in chief provided that where the documents are filed and the parties rely upon the documents, the proof and admissibility of such documents which are filed along with affidavit shall be subject to the orders of the court. So kindly observe this. Nothing.
What is observation? This is the law. This is observation.
At least I can.
Statute says so.
At least I can take all these points.
To take all these points. Who can oust you from taking those points? When you are under the law, you can take these points.
As your lord.
Ashwin. This application under Article 227 of the Yes, next.
Grateful.
Yes.
My lord, petitioner is the plaintiff in a suit for specific performance.
What do you want?
Expeditious disposal. My lord,
Size of the petition, from me, I could gather that it is an expeditious hearing. Nowadays, the expeditious hearing matters is very bulky.
my lord, what happens? All the orders, my lord, have to be produced. My lord, PW1 to PW4 already deposed of.
You have also annexed the Vakalatnama also. You have not annexed.
No.
Thank you.
The applications. My lord,
What is the stage?
my lord, PW1 to PW4 deposed of, then DW.
PW?
1 to 4 already deposed, cross examination finished, DW1 started, then they made application for amendment saying that some documents are needed to be produced. They produced that, then handwriting expert application has been made and allowed. That may be expedited. That the court may kindly send some reminders so that that handwriting expert might expedite his report and send it quickly. Suit of 2001.
So it has been sent to the handwriting expert.
Yes, yes. Lord,
What was the date fixed for receiving? 17th of January. What happened on that date?
Lord, awaiting report.
This application under Article 227 of the
But in this matter, I am appearing for the petition.
yes.
But this matter pertains to to expeditious disposal of a matter which has been instituted in the year 2006 by this plaintiff
Can I
petitioner.
take up this matter?
My lord, yes, my lord. Yesterday also, my lord told this. But I have taken instruction. My lord personally has no difficulty to take up this matter. But on the defendant side, one of the related.
Then how can I take up? Since I am not inclined to take up this matter. Yes.
My lord, yesterday my friend had come and said fairly that the matter must be sent back to the trial judge. But my lord, only.
Today they may take change their stance.
Oh, okay.
Lordship, I will cite a judgment.
Please use the microphone.
Lordship, not only the three code deposits were bad deposits, but it appears that.
I'm so sorry. You reach out.
Yes, yes.
But it appears that the first tender of rent control, when prior to the deposit in the rent controller, that tender is itself invalid.
But that is not the finding.
Lordship, Lordship, what we are of the view is that, it's my submission, that keeping the, your Lordship may remand the matter once again for a fresh hearing, keeping all points open. And since we were not given the challans prior hand, so we could not deal with it in your written objection. So we can be at the liberty can be granted so that.
Give me a minute, because let me go through the impugned order. On that day it took place, but I forgot.
Let them please.
No, this is the recalling. Where is the parent order?
1912.
My lord, that is that, my
1912.
lord, the order just before the order.
Yes, I've got that.
1912.
19 December.
Today is fixed for final.
Give me a minute. There are two ways of looking at it. One is that the learned trial judge held that these deposits for July, August and October are bad deposits. According to him, on the ground that those were not deposited, but according to him, those were within the time. Leaving apart the first one.
First one is bad.
First one, June. First one is of June.
My lord.
So June, there is no finding. So now, let us take these two things.
My lord.
The question is, those were deposited before the rent controller.
Right.
Good, bad, indifferent, maybe good, maybe bad. Let us accept that all those were bad, but he had deposited that. And it's not admitted by him, the earlier matter, which I have said that there also it was deposited. Same reasoning, that since it has been held to be bad, you ought to have, that reasoning cannot be supported. Now, even assuming that your June is bad, even then they have to be given. So instead of relegating, this can be expedited because they will have to deposit this amount, because only for June and these 4 months.
May I say? If
you want, I can relegate that. But whether that will be also of use, because they cannot, because they are not admitting that.
Well, the one thing is what we want to argue is, because his first tender is
I appreciate that. First tender.
All subsequent tenders are bad.
Bad.
Right.
I accept that. But that is the result of an adjudication. That is the result of an adjudication.
Yes.
That is not admitted by him to be due.
No,
so
that is what I'm saying.
The court, while holding that those are bad deposits, have to give an opportunity to deposit. If that is so, whether it will improve, I can relegate that.
My lord, kindly relegates that first, because let the adjudication be done on merits of the matter and not on his admission. Number one. Because here the court has completely proceeded on his admission that these three are bad. Court has proceeded on the admission that he has admitted.
Who has admitted? The advocate.
That is what I'm saying. Let it not be taken as sacrosanct. Let it be set aside on that ground. That
Mr. Ghosh, this will only delay your suit. Again, another round of litigation will come.
My lord,
Or the other round of litigation.
I appreciate,
Because even if it is, if your contention is accepted, let us accept your
Yes,
contention.
at best, and
At
everything is bad.
Everything is
Then
bad.
also he has to be given a chance to
So
deposit.
I
But
think-
let him, but one thing is there, my lord, if he, our case is, my lord, kindly considers the West Bengal premise. I know your lordship has taken another view. My lord, kindly considers, my lord, 20, my lord, 2, subsection 2. He has to come with clean hands. It's 22
Ghosh, that is
says
there.
no deposit of
Mr.
rent.
Mr. Ghosh, that is there. This may be as per that is why this is bad. So that is the result of an adjudication. This he is not admitting.
So he's not, I am saying kindly,
So if he is not admitting, so that clause will not be there. And he cannot be ousted from that, from giving an opportunity to deposit.
no, subject to correction, my lord, we are saying that you ought to have come and with clean hands and accepted before the court that even while making the 7-1 application, that all these amounts are due. You did not do so. You only admitted a portion, gave 7-1, and there are.
Mr.
then
Ghosh,
7-2.
for that is 7-2 is an adjudication.
That's right. So I'm saying,
So adjudication,
my lord, the client wants, let the learned judge, your lordship, sets aside on that ground that is not admission because these rent receipts and all were not available to us. He has only produced at the time of hearing.
I'm accepting your submission. These are bad.
Let him pass an order. Let the learned trial judge pass an order. Kindly, my lord.
He is smiling. He wants that.
Those are my instructions, my lord. Kindly, I appreciate what is for from the lordship, but my lord, kindly remind them.
Where is the
Let the learned judge, my lord, adjudicate. And
Yes.
if the learned judge comes to a finding that these are bad
Where is
deposits,
my earlier order?
Sorry, जो pass आगे order to दो.
And where is the admission taken note of?
My lord, that is, my lord, at page,
yes,
my lord,
first paragraph
first paragraph.
Of
my lord, 19th December 2024. Your lordship will see, my lord, the second paragraph. It is submitted. It is submitted by the learned counsel for the plaintiffs that deposits for the months of so and so are bad deposits, and therefore, and then the next sentence, the defendants admitted the deposits for the months of so and so as bad deposits. This I have clarified. My advocate has put in a personal affidavit clarifying that this was not what was submitted. It was misconstrued.
Kindly on that ground, let us get an opportunity.
Where is that
to file a
affidavit?
objection.
That affidavit is at page 127.
that apart, it is a point of law. This is a point of law whether concession of the, even assuming whether it can bind the.
No, that is settled, my lord. I
am not pressing
have
not
authority.
pressing it. I have advised, I am not pressing it. Let us not go into this. Let the learned trial judge give a decision on facts after giving us an opportunity to deal with his rent.
You have a
receipts.
copy of that judgment?
I have got its soft copy.
My lord.
Hey, ও তো hard copy, কোথায় গেল? কপিটা রাখো।
This application under Article 227 of the Constitution All things cannot be done from here.
No, my lord, I'll do my job.
Best with 6 weeks, preferably within 6 weeks.
Expeditiously, because this affidavit sufficient time is to be given. Give some breathing space to the chief judge will do.
I think
Sufficiently experienced person.
Very fast. Very fast.
So
But sometimes fast, my lord, leads to.
that is a different thing. So
Yes.
it has proceeded, it's proceeding expeditiously. Please don't put pressures on the judicial officers.
Grateful.
Yes, next. Yes,
50 upgraded motion.
After the petitioner plaintiff lordship,
Yes.
the plaintiff petitioner filed the title suit for permanent injunction and declaration of title lordship. I have to file the affidavit of
for the
service.
opposite party. Yes,
On 16th June 24, 2024, 14 lordship, the plaintiff petitioner filed an application for police help lordship. There is a status quo order lordship. But that application was not heard lordship. Years together, date was adjourned lordship. Therefore, the plaintiff petitioner filed application for not pressing the application for police help. That was also not heard lordship.
that was also not hard.
No lordship. Next date fixed on.
Non-prosecution, why are you objecting to that?
In the meantime, they moved 3 petitions.
That was not maintainable as the police help application is pending.
Trial court just fixed the date of hearing.
Of that application. What is the date fixed?
13th June, the date is fixed for hearing on
I'm directing the Lana trial judge to dispose of on that date.
within
itself.
certain time, lordship.
On
Yes,
that date itself, what certain
On
time?
13th July.
Not pressing application,
On
you are opposing.
They have gained some advantage. That's why they are suppressed. All these orders are.
Yes, together, lordship. Since 2014, lordship, I have on.
Pressing that
Yes,
application.
I am not pressing.
That trial could decide that. I will raise that objection. Some cost may be because they suppress that. Lot of orders of the single charge.
Of the petition.
on. That will be run
I've
further.
said to take up the hearing on that date. Both of you make short submissions, it will be disposed of. Yes. Led by? Microphone is not working.
I'm led by Mrs. Sanjukta Ray. I'm praying for short passover. She is on her way.
There is a secret history. This Somabaika, the state government doing is the tenant under LIC.
Somabaika tenant under LIC, yes.
So PP Act will apply. An eviction order has been passed.
Vacate, Mr. Basu.
That's why I am here to vacate.
To oppose.
Eviction order has been passed. If you lordship see the order of eviction, one will be astonished.
But that is not the challenge here.
No, I cannot.
Then appeal.
Appeal has been preferred. In appeal, my lord, initially order has been granted for stay of 50,000 contractual rent. It was directed.
1.5.
1.5.
15,000. What is the extent, Mr. Basu?
That depends upon the order of the trial court. If there is a reason order which can stand, maybe set aside, may not be.
All right, 15,000.
Then, my lord, we could not appear. Behind our back, it enhanced to 1,15,000.
1 lakh?
15,000 per month.
So only 1 lakh has been added.
150.
1 lakh 50.
50.
Yes, 1 lakh 50.
Enhanced. That order, there is the condition that this, if this payment is not made, the order will be automatically vacated. It's not there. I'm precisely on that. Normally, whenever lordship enhance it, if you not pay, interim order will be vacated. That part of the order is not there. I could not deposit. I made an application under legal advice for review without coming your lordship's court. In the meantime, they took forcible possession. In spite of order of stay was granted there. Against that order of enhancement, I am before my. Coupled with the order, the action of.
Now you have been dispossessed, Mr. Basu.
In the teeth of an interim order.
Yes. So now what is there with the occupation charges? You.
I know, but how I'm asking the question myself. How I can be evicted by a Article 12 authority against Article 12?
That is not before me.
No.
Now it's the question of enhancement. So enhancement, it has lost its force, Mr. Basu.
My lord is 227 code. I am not your lordship. I can recall 41 CWN. 227 code is to make all wrong right.
But you have filed an application for restoration.
I have not. It is, according to me, it is not necessary. If I have been dispossessed, my lord, at least 3 judgments, your lordship can immediately come to your lordship mind that if anything has been done in the teeth of an interim order, it is non-est. But before that, balance for your lordship's consents to be secure, kindly come to the order of eviction. Is it an order of like, I think my lord has not seen this type of order of eviction under the PPI. May I read with you, Lord? 17. 17.
17.
17.
17%.
17.
Internal.
As far as Kali got it. Allow me to read.
17 I have got.
Kali, allow me to read. Reason. This is the reason. You have opposite party, despite repeated requests of the applicant, have neglected to accept the most moderate upward revision for rent for some more than 2 decades. You, the OP, have made unauthorized construction in the form of mezzanine floor without written approval consent of the applicant. This was the allegation in the application. Then, your authority to occupy the premises was determined by the appellate authority by notice as such and such, and requiring you to vacate the delivery of the possession. You illegally and wrongfully failed and neglected to quit, vacate and deliver a possession of the premises in the authority in terms of the aforesaid quit notice or at all, and have thereby been unauthorized occupation of the premises number such and such. That's all.
Lordship, this is the order B. This is not the order.
Let us see what's the order.
Main order has not been annexed. Main order has not been annexed.
That is the order.
You
I
saw
have
the
the order.
yes. Page 20. Kali 20 also leave. Now therefore, in exercise of the power conferred on me Under section size, you are.
No, where is the order?
What is the order?
No,
19
it
and
says
20.
it's not the order.
Can it stand for a single minute scrutiny? This is order is subject to appeal under section 8. Your lordship's got time without number says if the order is subject to appeal, reason has to be there.
8 or 9?
Just
Appeal is under
section 8.
8.
Appeal, or 9.
I was
I'm
thinking
getting
that
old and my lord is now young, gradually.
I was thinking that I'm not in touch with these matters for a long time.
In this branch now you have come, and again it will be.
Yes, where is the order?
After this, I am 227 proceeding. Can this order be stand for a single minute scrutiny?
Page 20. But Mr. Basu, the
Lordship,
there
may I
is an-
come back with the order because
there is an
I can't
appeal.
find it in my.
So I can direct the appeal to be disposed of.
I know.
Mr. Basu,
This order and thereafter, my lord, now kindly come to
now you have been dispossessed also.
now in the teeth of an, I repeat, in the teeth of an injunction,
Yes.
your lordship's court can restore it.
Mr.
Lordship,
Basu, restoring is one thing. Now, the appeal, you have preferred a statutory
Appeal. In that appeal,
So in the
injunction granted,
injunction,
and thereafter
I'm not on that.
beyond not back.
If you have availed of the statutory remedy, I can direct the appeal to be disposed of. That is the only point of law. You can show this and the appeal can be disposed of in a short time.
Know that. But they will be.
Why are you fighting, Mr. Basu, with the occupation charges? Occupation charges, now it's gone. If you succeed in the appeal, everything goes.
I know that. But in the meantime, Lord,
Because now you are not required to pay any occupation charges.
no, that has gone.
That
From
has
this
gone.
court.
So you are fighting with something, you
that.
will not get anything.
The verbatim I have told to my learned friend.
So I'm
assistant.
directing the appeal to be disposed of.
But in the meantime, what will happen? My goods
I
are.
will also direct to
My
consider
Somabaika, my lord, the experience of Somabaika.
to direct your consideration of your prayer for restoration of possession. Have you filed any application?
Not yet.
You file an
I am before
application.
my lord.
I file an application. I will direct that also to be considered. Or if you want the appeal to be decided once for all, it can.
But what appeal to be
Let the appeal be decided once for
what
all
to be
because it
decided?
is at
This
the
is the
final
order.
stage. It's at the argument stage.
Appeal is at the argument
Yes,
stage.
Your Lordship. The notes on argument are to be filed and the verdict is to be
It's at
passed.
the argument stage. I am directing the appeal.
Lordship, the appeal.
What to be decided? My lord has seen the order.
Mr. Basu,
My lord,
The
had it not been
appeal-
115, I could not have asked this question.
Mr. Basu, I appreciate, but since you have approached, you have not directly come to this court.
No.
So you have approached a statutory remedy. So I'm directing that she says, I think that is also your instruction. It's at the argument stage.
Yes, because you have taken time for this. Could
And
not
if
be
you
hard.
want, there are two options. So if you want your restoration of possession, it will get delayed. If you are confident of the appeal, I can direct the.
My lord has seen the order. My lord is confident. Had even this side.
But
Lordship, let me.
second thing is, if you want immediate restoration, I can also give you liberty to file an application for consideration. I think, but that will can delay you the appeal. Choice is yours.
Lordship,
My lord, let the lower appellate court hear me and pass the order. Appellate court.
You may appeal.
Main appeal.
But I am recording your submission.
Restoration এখন কি হবে? Appeal যদি চলে যায় হয়ে গেল।
What is the next date, madam?
Lordship, next date is
27th
of this month.
This month.
That's why
Lordship, this week only we have the matter. Friday most probably.
Friday,
Friday, Lordship.
28th.
Lordship.
So I'm saying shortly on the
Kindly
next.
record my submission. It will
Yes,
help.
yes, I will record your submission.
Because of the
27th, Lordship.
I've argued. Record.
Yes, yes, yes.
This is the order.
Lordship, only one thing I would like to submit, Lordship. The appeal has been filed in the year 2007. And once they obtained an interim order, a conditional order, they just went into
Now,
their
madam,
slumber.
they are out of possession. So the appeal
Now-
has to be decided. Appeal has to be decided. Nakiola, this application, For the private respondents,
Yes.
what relief you are seeking in a writ?
I am not, I am only to, Principal Lordship to dispose of the hard the matter because my lord, what
That
happened?
cannot be a
What
ground.
happened, my lord? Your lordship, can you hear me, my lord?
That cannot be a ground, yes.
But my matter was hard last week and it was disposed of due to default. Now the problem is I have filed one can for restoration on last Friday, but the matter is not yet listed. Now
Can will come in due course.
now the KMC has came for excavation. Now there is a gross miscarriage of justice. The KMC in its report had mentioned the western side that
Come tomorrow, mention
My lord, yesterday my lord had heard this matter, my lord. From the,
what?
From the urgent determination of Justice Kaushik Chandra.
What is the urgency?
And my lord,
What is the urgency?
demolition will happen today, my lord.
Will happen today?
Yes, my lord.
Will happen or it has started?
Not yet, but it's supposed
Which
to.
municipality?
Calcutta Municipal Corporation.
Who is appearing?
My lord, yesterday from the Banerjee.
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 And who is appearing for the respondents?
My lord,
Yesterday's matter. Who is appearing for the respondent?
my lord, till now nobody.
You have served.
We have served to two and one rejected, so we have done a postal service, my lord.
All right, come at 2.
My lord, in my matter also the excavation is
Today there is no
started.
exactly, Mr. Basu.
My lord, may I come back tomorrow?
Normally Friday.
But my construction work is stay, my lord, my
No 3:30.
Normally Friday.
Normally Friday.
my lord, my construction was, I could not carry my construction was
Samay.
for my lord, only for,
My lord,
for
this
pendency of the
excavation
execution.
is
May I come back tomorrow, my lord? Grateful, my lord. অবস্থা
With regard to a matter listed before my Lord Justice Chandra, my Lord, there are some urgency, my Lord. What happened, my Lord? Petitioner is a particular owner of a particular plot of land which is within the periphery of Vishwabharati.
Periphery of
Vishwabharati. Because while constructing Vishwabharati, Rabindranath Tagore, my Lord, sold some of the land to individual person. So the petitioner.
So what is the urgency?
Urgency is this, my Lord, this land had road in both two sides. One side, the Vishwabharati already constructed the boundary wall and blocked my drainage system. In another side, they have issued notice saying that this portion has of the road, they have
issued notice. Municipality.
Yes, Vishwabharati, my Lord, the construction raised by the Vishwabharati.
But this is municipality matter.
Yes, this is municipality matter because the road belonged to one side road belonged to municipality where the Vishwabharati has already.
Who are appearing?
My Lord, I will serve notice to my Lord tomorrow at 2 p.m. my Lord. I will inform the Vishwabharati and others, my Lord, over the electronic mail, my Lord. Item number, my Lord.
Do not wait till the next week, Mr. Bhattacharya. Is it so urgent?
The difficulty is
only the urgent.
Yes, my Lord. My Lord, the only difficulty is 20th. They have started digging the earth, my Lord.
20th.
20th. I made a complaint before the police station. After that, on 21st, on their website, they are saying that this road will temporarily remain closed. And my Lord, I apprehend that in the girls of my Lord, this raising the drainage system, they will completely block my Lord, my egress and ingress. This is nothing but a land grabbing of Vishwa.
The soft copies upon all.
Everybody, my Lord. I'll just intimate.
Please intimate. Tomorrow it will appear in the list. Time I will indicate, but it will appear in the list tomorrow. Kalke list.
Item number Item number 190. And this is my Lord, the notice in their website, my Lord. That is the urgency.
All right, keep it with you. So it will appear tomorrow.
I will send intimation.
Please inform me. Yes, call the list.
Bhattacharya is appearing in this matter.
Madam,
on
I am
behalf of
appearing
the
for
opposite
the
party.
petitioner.
Item number 52.
Yes, ma'am.
Mr. Bhattacharya is
Yes.
appearing.
On behalf of the opposite party. No, no.
My lord. On the last.
Since I am not inclined to take up this matter on personal ground, this matter stands released.
Item number 53. Mr. Chittopriya Ghosh is appearing on behalf of the petitioner. It is my instruction, my lord. This matter was due to appear tomorrow, my lord. It has wrongly appeared today. It was due to
wrongly appeared
26th, my lord. It was due to appear on 26th.
tomorrow. Not today. Yes, next.
I'm grateful, your lordship.
54.
Item number 54, my lord. This is my civil revision application rejecting the application under Order 6 Rule 70. So the trial has
under Order 6. Yes.
Yes, ma'am. But the trial has not been commenced. I want to add certain facts which the learned court below dismissed. Dismissed ex parte.
Yes.
But the service has also been made. The other side chosen not to appear on the last occasion also. Again, the Justice Raja Basu Chaudhary has directed me to again serve. The service has been made. Well, this is the affidavit of service.
Yes, what do you want?
Well, I want that 6 Rule 17 application, but that has been rejected. I come before your lordship, let it be allowed. Well, what
is the date of the order?
But the date of the order is 20th March 24.
20th March.
Well, no reason has been given, nothing. 20th March, well, the last.
It's March. 20th March, the certified copy, the order date is 20th June.
No, it's subject to correction.
বলছি তাই।
Oh,
wrong file. These were all within your knowledge. This was prior to the filing of the suit.
absolutely. Malad, that was kindly consider. That was in my knowledge, but the erstwhile advocate did not take up that thing. I am coming to the judgment on this point. Kindly rely. I am considering the judgment. But at my point, the 6 to 17 may be allowed until unless that fact will come. I did not give by way of evidence. That is the difficulty. And that is the main difficulty.
At what stage? What is
At
the stage of the suit?
framing of issues. When the application was taken up, that was in the framing of issues. The trial is not after framing of issues. It was in the order also. 28 March 24. The said facts have been noted in the plaint that the petitioner wants to amend the plaint after framing of issue and at the stage of evidence. The evidence has not been commenced on that date. I have filed the 6 to 17 application.
What are the facts we want to insert?
I am coming, that there are certain number of complaint and GDs we have made before the concerned police station regard to my wife that has not been included in the plaint. 6A that the petitioner stated the petitioner even on 18/11/2018 lodged the complaint before the concerned police station in respect of the illegal and mental act which the opposite party did with the petitioner and the same amounts to mental pressure upon the husband which creates mental cruelty. Thereafter, FIR has also been made, certain documents. But that part where the court
What
will
is the date of the complaint?
Well, the date of the complaint is 8th November 2018. Thereafter, again, my lord, the GD has also been made in the year 2019. Thereafter, in the 21 also. In the 14A, if my lord will kindly see the last paragraph of page number 56.
What is the date of 2018 complaint?
The 2018 complaint, my lord, the date is at 8th November 2018. 8th November.
That is prior to Diwali.
Prior to Diwali.
That fact has been stated in page 21 of your original plaint.
Yes. Lord, kindly.
So
yes, that part and my lord thereafter again, if my lord will see 6B, that part is there. My lord, that the
14,
the GR, the GD, and thereafter my lord
stated.
Lord,
Those facts have been stated in the plaint.
but my lord, kindly see for 14A, if my lord will kindly see, that after filing of the instant suit, the opposite party herein regularly visited the workplace of your
2014 complaint is at paragraph 6.
Yes. 20, my lord, I'm telling about 21. 19th April 21. Thereafter again we have made 27th March, thereafter again and again. My lord, they are regularly doing the same thing again and again. We have made the complaint. Well, that part will be decided in the trial. If I will not come in with that, the court will not taken up.
You don't want your suit to be disposed of.
Well, I am ready. Well, kindly the suit be expedited. I am not.
Cannot be.
Well, I
Cannot be.
But that part, that
To be hard.
that part.
By the order impugned, the application for amendment of the plaint stood rejected. Petitioner is directed to serve a copy of this application by register speed post with acknowledgement.
Well, that has been done. That has been done on 2 times, but they chosen not to appear. Now, kindly see the last order passed by Justice Raja Basu Chaudhary. Well, they have directed, they have chosen not to appear. I have filed the affidavit of service. Again today I have made. Again today I have made. Well, this is the affidavit of service.
No, for upgradation mentioning you have given.
Well, I have given all the notice, my lord, that the
upgradation. After
not for the
upgradation,
upgradation. Not for the upgradation. Then, my only prayer, kindly give me a limited stay.
The order impugned the
notice.
This matter was mentioned by the petitioner for upgradation, and considering such prayer, this matter was directed to appear under the heading upgraded motion. First of the learned advocate appearing for the petitioner, in his usual fairness, submits that no notice prior to upgradation of this matter was served upon the opposite party. First up, paragraph, petitioner is directed to serve a notice upon the opposite parties. First up, affidavit service filed in court today is taken on record. ওইটা একদম উপরে লিখে দেবে না affidavit service যেটা first up, there shall be an order of stay of all further proceedings in matrimonial suit number 200 of 2018 pending before the learned additional principal judge additional principal judge family court Calcutta till the end of June 2025 or until further orders, whichever is earlier. List this matter under the heading contested application in the monthly list of June 2025.
I'm grateful.
Yes. Next.
55.
55?
I am appearing
55?
Yes, I am for the petition.
Yes.
The opposite party husband filed a suit for divorce. Now, in that proceeding, the section, the wife filed section 24 application that was disposed of. Now, here, section 24 application that was disposed of.
Yes.
Now, here, the petitioner challenging the order, wherein the petitioner asking for educational expenses of her son, who is whose admission is in class 11. Now, on the last occasion, when the matter was taken up, this court directed my learned friend's client to
class 11. When your son passed out?
My son passed out in the year of 2023. But due to the paucity of fund, I am unable to admit my son for 1 year. Now, the urgency is this. Again, the session come.
I already contacted my son. My son is interested to study in engineering, diploma engineer. Already I taken steps.
You have taken steps.
But the withhold the certificate.
But I don't have.
Withhold the certificate regarding Madhyamik pass and
I don't have any such instruction, my lord,
Bhattacharyji,
because for last 2 years,
father says that yes.
yes, I'm ready to. I'm
When
ready.
he will be admitted? What is the date for admission?
Admission, my lord, in May, June, my lord, the class will be started. My lord, I already contact.
No exam is necessary for any entrance examination or
Entrance examination, diploma engineering, my lord, is
not necessary.
I think, my lord, it's necessary, my lord. I think.
But, my lord, can you produce, my lord, the son before your lordship?
Why?
My lord, because, my lord,
I will direct production of the son before both of you. I will appoint both of you as
Because, my lord, the
joint
husband.
I will direct the son to be produced before both of you. You interact with the son. You are the officers of the court. Court have every faith in both of you.
well, then one problem may be solved.
Yes,
Problem may be solved.
Problem
All
may be
right.
solved,
Because the husband on the one hand, a husband on the one hand did not pay a single further money to the mother. Execution case is pending.
If the husband now says, he has
I'm
taken
ready with.
steps,
I'm ready with.
so
If my
please
son,
cooperate, you have to give
yes, my
those
lord,
certificates and other things.
my lord, I will hand over.
Where you want to admit your
Just
son,
yes, my lord, just
disclose this.
I shall disclose. My lord, I shall disclose.
kindly take it up this matter on the next week. Meanwhile, I will talk with Mr. Mukherjee. If he disclose, my lord, where he want to admit her son, I will hand over all the documents.
When this matter is taken up for hearing, the learned advocate appearing for the opposite party submits that
Proceeding continues.
fight against yourself, but not for the
Yes,
son.
absolutely,
For
my
the son, please do something for
Absolutely.
the son. Both of you, I'm requesting you. As paid for by the learned advocates for the parties, list this matter. Yes, Mr. Rai.
No, the defendant is the petitioner before your lordship in a suit for eviction. 7-3 allow keeping pending 7-2.
Not eviction degree not yet passed.
Probably from here.
Yes.
Now, my lord, if your lordship can turn to the paragraph 4, where stated when 18/12/2021 I received
What is
the
the impugned order?
allowing 7-3
You have
for
not complied.
alleged non-compliance 7-1 without deciding 7-2.
Without deciding 7-2. You have filed 7-2. 7-1 you have complied with, or there is a dispute. What is the dispute?
Yes. 37,000 admitted area.
37,000 admitted area.
We have
You have not
stated,
deposited that.
we have stated in my application 7-1 that the construction work and other things, the 7,900 was spent.
Adjustment.
Adjustment, and for that rest 2 months, I have deposited.
Thereafter,
7 to file, if it is held,
thereafter,
I am continuing. I am
thereafter
continuing.
there is no default.
There is thereafter no default. I could have understood after that there is default. Admitted rent, it is my admission. Yes. 200, 2000, 100, 800 is admitted due. I filed 7.2 application. My lord, that's why, my lord, I am drawing lots of attention. Only 7.1 and 7.2 application. Page 33, my lord. Your lordship can turn to page 33. My lord is going to impute order. My lord will not find anything. My lord will not find any adjudication. 7.1a, 7b.
You are not hard. You are not hard.
No. Hearing was there. 7.
Where is your submission recorded?
Nothing. Only 7.1 and 7.2. That is why, my lord, precisely I am coming.
Mr. Rai, you prayed for an adjournment.
No, after that, my lord. Probably, my lord is.
That was allowed.
No, Lord Advocate, the defendant raised the objection by filing.
Where? Which portion you are reading?
Ordered dated 5th April 2023.
But prior to that, the prayer for adjournment was considered and allowed. Cost of such and such not yet paid.
That cost of rupees 300. That is for the purpose of the commissioner. After that, now petition under 7.3.
Oh, this was adjournment of what application?
Today's fixed
I
order.
understand because
7.3. Today is fixed for order in respect of petition under section 7.3 of the hearing of petition dated 7.2 and cost of rupees 300 by the defendant and filing a copy of the challan. Letter for the defendant, letter plaintiff files one adjournment. It is the plaintiff who files an adjournment application for non-depositing the cost. So I have participated in the proceedings.
No, the court was of the view since you have not deposited the admitted arrears.
Yes.
So there is no necessity to decide 7.2.
I bow down to your lordship. Your lordship can turn to the middle portion of the middle paragraph. Lord Advocate for the defendant has raised objection. Well, got it.
Yes, yes.
Such and such regarding construction of soft room business by his own space.
Your application.
Yes. Well, can I turn to my application page 33?
33.
Yes, page 33 and it's B.
33 7.1.
7.1. Yes, my lord.
7.1 is the no dispute situation.
No, admitted rent, admitted area.
7, if you are disputing.
Yes.
If you dispute, you have to file 7.2.
7.1
is a no dispute situation.
Yes. What is it? Whatever admitted area, I have to deposit. Admitted area amount.
That is dispute. Because the plaintiff says this much is the due. You do not admit that. You say no, that much is not in due. So if a dispute arises,
then also, my lord,
section 7.1 says if there is no dispute.
No, subject to question, my lord, admitted area amount.
That is 7.2.
No, my subject to question, my lord, if your lordship can consider.
Yes.
7.1a. On a suit being instituted by the landlord for eviction of on any of the grounds referred in section 6, the tenants are subject to provision of subsection 2 of this pay the landlord or the deposit with the all areas of rent.
Yes.
Calculated.
Section 7.2.
Yes, subject
all areas of rent.
rent.
So this is not dispute. 2 says dispute.
Yes.
So
this what
follows that 1 is there is no dispute with regard to the areas.
There is
no dispute situation, Mr. Rai. That is why subject to the provisions of section 7.2, if there is a dispute, you did not pay.
No.
Let us suppose the plaintiff says you are in default of 10 months. It says such and such is the rate of rent, such and such is the period of default. You dispute that. You say no, this is not the rate of rent, this is not the period of default, this is the rate of rent, and I have deposited everything. For adjudication of that 7.1, according to you, there is no arrears.
No, the area is there. That is why precisely my lord 7.1. That is why my lord 7.1. Which is the last paid?
You said, Mr. Rai, you said that you have spent something, you want adjustment. So it's a dispute. Plaintiff is not admitting that.
Yes. After adjustment, this is the amount due.
till now January, I have deposited the same.
7-2.
7-1. This is subject to consideration. What is the admission on my part? I have to comply with at the time of filing 7-1. Unless until I comply with 7-1, I cannot invoke 7-2.
Mr. Rai, if there is a dispute, are you required to comply with 7-1 first?
Yes, my lord. Save and accept, my lord, relationship. If I dispute the relationship between the parties,
If there is a dispute as to the rate of rent,
I have to, according to me, what is the admitted amount I have to deposit?
that is, Mr. Rai, that is 7-2. Kindly come to 7-2. If in any suit there is any dispute as to the amount payable, this follows within this.
Yes, before the 7-1.
Once, not 7-2, kindly see the opening part of 7-2. There is any dispute as to the amount of rent payable by the tenant. So it is rate as well as period.
That
so
is why,
once you raise a dispute, no, this is not the amount, I want some adjustment, everything comes under 7-2.
subject to question, my lord.
Right,
But
so now what happens?
My lord, this is, be as it be, my lord, I'll,
Yes, now
7-2 I have filed
Yes.
also. In
7-2.
7-1 I have categorically stated this is the amount, page 35.
Yes.
That suddenly I have deposited that I have constructed the building and I am entitled to get such adjustment and rest amount I am depositing. So if there is anything, I'll deposit.
Sir, your copy also contains these calculations, handwritten calculations. Contains, it does not contain. These are part of these petitions, these calculations. Yes, yes. So only 1,120 is the, after adjustment, that is arrears.
Arrears.
Admitted, you have deposited.
I have deposited. The court is of the opinion you have to deposit 37,000 at the, for invoking 7-2.
under the heading contested application in the yes.
Your Lordship, I'm appearing for the petitioner hearing.
I'm for the opposite party.
Yes.
Lordship, the matter, the petitioner preferred this revisional application against an impugned order passed in the title suit 215 of 2016, pending before the civil judge senior division.
What is the order and the challenge?
Order and the challenge is the petitioner has been contesting this suit since 2019. They have the petitioner had filed the written statement in the year 2019. Subsequently, the petitioner filed and petitioner defendant filed an application under Order 6, Rule 17, and the order and the application was rejected on the ground of non-appearance of the petitioner defendant. And the learned court was pleased to fix the matter, fix the suit as expertise. On the next date, the petitioner defendant subsequently filed an ex parte vacating application, and the same has been rejected by the learned.
That is the order impugned. Where is the application for setting aside the ex parte order? Where is your application?
Lordship, that has not been annexed here.
You have a copy of that application?
I don't have a copy of this. But one difficulty is, Lordship, one difficulty is the next date before the learned trial court is tomorrow.
What can be done? You have
Lordship,
not filed that application along with the revision application. You have also not having the copy of the same.
Lordship, it is a suit for partition. It is at their mistake that the suit has been done ex parte. It may be allowed with cost, your Lordship. But one thing, your Lordship, the evidence.
How much cost you want?
That your Lordship decided.
You say you have taken a very reasonable stand. You say what will be the amount of cost?
Your Lordship, you decided.
What will be the reasonable amount according to you?
Your Lordship decides. I cannot say, your Lordship.
You can tell what is the reasonable amount.
5,000 like that. 5,000 to 10,000.
5,000.
Your Lordship, one submission.
You are not agreeable to that?
No, one submission regarding the rejection of the application for ex parte hearing. The learned court recorded that no WS has been filed. On this ground, the learned court.
He is agreeing to your prayer.
Lordship, please.
Your Lordship, one thing, your Lordship, the evidence has been completed on the part of the plaintiff, your Lordship. So if they want to do anything regarding that, let it be done in a
So Mahato, you are appearing. Can I take up this matter? Have you inquired?
Yes, your Lordship, we have served the.
Who is your advocate?
Wait.
Mr. Mahato, who has sent the brief to you? Who is your advocate?
My lord, from Alipur Court, I have received it. From Mr.
Lordship, on the last occasion, an affidavit of service has been handed over to the court and it has been kept with the record.
Priti Ranjan Rai, that is my lord, practicing Alipur Court.
Is practicing in Alipur.
Alipur. But I do not know subsequently whether some change has been taken. May I come back after taking instruction?
I think it's.
So, Lordship, kindly stay the proceedings before the learned trial court. Tomorrow is the next date, your Lordship.
Mr. Mahato, can you take instructions over phone?
My lord, I am. Kindly give
Please
me half
take
an hour's time.
instructions. Who are the conducting advocates of Buddha? Come at 4:15 today.
I'm good.
Yes.
On the basis of a direction.
On the last occasion, Lordship extended the interim order and was pleased to, my lord, observe orally that it will be coming in April month list.
extension I have not opposed.
My lord,
Yes.
may I please, my lord?
Why it is appearing under the heading upgraded?
I-
Must be at the mentioning.
I have not been served any notice.
You have mentioned this matter.
It was running in the combined list.
Yes. Look, he has been mentioned.
I didn't, I was,
That
even
is
on
why I
that,
fixed a date.
even,
see.
even on that day, my lord, I was not on notice. I have seen it in, my lord, list and I have.
2015, the suit is running expert in the lower court.
Kindly see his mentioning slip. Dekhan.
My lord, page 45, my lord will see.
It was extended till
It was-
April.
it
You have not
was-
stated
It
that.
was, your lordship was given the impression that the interim order is
Kindly see,
extended.
it was in the mentioning slip what has been stated. If this is being done, I cannot accept any mentioning slip.
Oh, the matter was taken up after this. At that relevant point of time, the extension of interim order, there was an urgency. I have not opposed to the extension of interim order, which your lordship has pleased to, my lord, extend. Now, my lord, it should go back to its original position.
My lord, on the day before yesterday, when my learned brother has intimated regarding the taking up the matter,
What
my
is
lord, he
this
could
matter,
have,
Mr. Lai,
he
you are
holding
not
the
ready?
brief in his hand, he could have prepared.
You are not ready.
No. Point is that I have also preferred a
9 days delay in filing the amended plan, that was rejected.
I have also preferred.
Donation petition was filed below, that was
You have
rejected.
also filed an application, but that is of the year 2023.
2023.
I cannot take up this.
That is why I had thought that I'll be mentioning the matter before the honorable judge, or if it is not there, I'll be
But
seeking.
that is not related with
It
this.
is related.
How?
Because this particular, my lord, order, which as of today he is seeking implementation, has been challenged by me in the 2023 CO. Kindly comes to this order.
Oh, this order is under challenge.
Yes. Page.
Order of rejection.
Order of reject. No, the order of grant. Kindly comes to the order passed by this honorable court in the first round.
No, show me the impugned order in this revision application.
In this.
My lord, the impugned order is the last page.
Last page.
Order dated
18th
18th of October
October
2023.
Yes.
18th October 23.
This,
which
That
is
was
a sequel.
rejection of, condonation of delay of 8 days in filing amended plan after it was allowed under the direction of the Honorable Justice Ajay Kumar Mukherjee.
so this was extended. So why have you challenged this order?
No, I am not challenging, my lord. The rejection order I have challenged.
Lordship is at which page, my lord?
My lord, my
Order
amended.
dated 18th of October 2023.
Yes, that is the input. Kindly comes to page. I'll just draw your lordship's cursory glance to page 61, which is the order of this honorable court. The prayer for amendment of
Here the order 6 rule 17 afresh.
that was heard. Page 65.
Page 65.
Yes. It was allowed.
It was granted, my lord.
And I am challenging this order. Grant.
Oh, you are challenging the order of amendment.
Yes.
Allowing amendment.
Yes. And my lord, it was granted and they were supposed to file within 14 days.
They have not filed that.
Not filed. So therefore, court has again refused to, my lord, extend that 14 days, which is impugned before lordship.
Oh, so this is the parent order.
Yes.
Awesome.
my lord, it is, my lord, it is
Because under
reflected in the order, that is the
না, এমনি তো কোথা থেকে ছিল?
CO number reflected in the order is the disposed of CO by the coordinate bench, not their CO number.
Yes. For the next matter.
But I appear for the opposite party number 1, my lord.
I appear for the performance for respondent, opposite party number 2, your lordship, ICICI Bank.
But it's a final order passed by the district commission, my lord. It's an appealable order, my lord. Final judgment of the district commission.
I have tried and satisfied your lordship on that.
Mr. Kormokar,
Lord,
please
with
prefer a
respect
replica.
to Lord,
On merits, if you are challenging,
this is
please.
not only on merits. Lord, kindly considers this. Lord, there is no existence of consumer dispute. Jurisdictional error.
But these points can be taken before the
that can be gone into by the appellate.
If I can prima facie show from the records itself, Lord, it is the order suffers from
Merits
jurisdiction.
have to be gone into whether there is a consumer dispute or not. For that, merits
No
are.
merits is required to be gone into. But the issue is whether registration charge.
The question of discretion of the court whether to entertain an application or not.
Yeah, absolutely. I bow down to that.
Mr.
Lord,
Lai,
why
Mr.
your lordship
Kormokar,
would
please.
exercise that jurisdiction in my favor? May I try and explain? Lord, may I try and explain, Lord, why the jurisdiction needs to be exercised in this case? May I try and explain? Lord, the issue is with respect to, Lord, sale of a particular vehicle. There is no question, there is no dispute with respect to the, Lord, quality of the vehicle. Lord, the only dispute is why the registering authorities did not register. In the invoice itself, I have shown to your lordship on the last occasion that there was a disclaimer.
Take steps for registration of the vehicle.
Yes. I have taken steps, and in furtherance of that, I filed a writ petition.
Mr. Kormokar, according to you, you have taken steps for registration.
My lord.
According to them, you have not taken steps.
My lord,
for
there is a
registration.
clear finding by the commission that no steps
Mr.
have been taken.
Kormokar, this is on facts whether there is a dispute or not.
This is not, Lord, that's exactly what I'm on. Lord, registration cannot be a
Not a, Mr. Kormokar, maybe registration is not your duty, but you are obliged to take steps to get the vehicle registered. Those preliminary steps, application, forwarding, submission, those are to be done by
the
you.
issue is, if the registration is not granted, I am not liable. That's a disclaimer.
That is a different thing altogether. But whether you have taken steps for that registration, what steps for that facts are to be gone.
Lord, those are all part of the record.
Maybe.
Lord, those are all part of the record.
Mr. Kormokar, then all appellable orders can be, has to be decided.
I'm not
So
saying
these are all
lordship
facts.
to open the Pandora's box. I'm not, Lord, asking, beseeching your
Kormokar,
lordship to
please,
say that.
I will make it clear, all points can be raised.
Lord, the problem is,
where is the Consumer Protection Act?
Lord,
might I have a minute?
But then there will be a question of limitation to be, Lord, addressed.
That is condonable, my lord.
You have, there is a provision for condonation.
Yes, Section 41, my
and
lord.
you have approached this court immediately thereafter.
Yes, yes. Lord,
So I will record that.
Lord, I had approached this court on 23rd of September 2024.
Section 41, my lord.
You have 29th of September 2024.
Yes.
When the order was passed.
The order was passed
16th of
in
January 2024.
Order was passed then.
Long
Well beyond 45
the
days. my lord.
difficulty
So
is
you have
otherwise,
approached the 227 court after the period of limitation.
that is there. The difficulty is otherwise. Lord, your lordship kindly considers this. Lord, today he is enjoying the vehicle. Today, kindly, Lord, kindly visualize the situation.
Hash out
Today
those points before the appellate. What is the section?
41, man.
41.
41.
This application under Article
opposite party number 2.
Which
said-
matter?
In this matter, item number 59, Lordship, I have instructions that to appear for the pro forma opposite party number 2, and what I know right now that my learned friend, he is also
We
appearing.
also had instructions, my lord. We
And-
appeared on the last occasion as well.
And that was the
So
situation.
both of you can appear, give both of
Like
your appear.
we both are from separate
Separate,
form, Lordship. So that is the problem now. So Lordship,
Was created by us, but once we served on the bank, the next time we served because they appear so we
Both
served.
of you can
Lordship, that
resolve
can-
amongst yourselves.
yes, Lordship. Just that the name,
Please resolve that prior to 4:30 and give who can appear.
Lordship.
If both of you can appear,
With Arnab Jha.
Lordship, Lordship.
yes.
Lordship, thank you.
Hey,
Great to hear that.
Just call the next matter.
আমাদের ওটা লিখে দিয়েছিল
60, my lord, I am appearing for the petition.
Yes, Mr. Chatterjee.
My lord, plaintiff is the petitioner before my lord. My lord, suit for my lord declaration of title and permanent injunction. My lord, by way of the impugned order, my lord, the trial court, my lord, has rejected, my lord, my filing of amended plaint. My lord, my show cause has been rejected. I tell your lordship, my
It
lord,
was not within time.
what happened, my lord, the trial court passed an order allowing my amendment. And my lord, in the operative part said it has to comply within the stipulated price as per the provision. And my lord, and the next date was fixed on
Provision is 14 days.
14 days. Now, my lord, and the next date in the trial court was fixed on, my lord, 9th of June 2023. My lord, on 9th of June, my lord,
You filed.
no, resolution was adopted by the court. My lord, I did not take any steps.
Chatterjee resolution exempts this filing of this.
No, my lord, I tell your lordship what happened, my lord, the
In which court?
this is from Howrah.
Have you checked up the resolution?
Yeah, my lord, this is an order I have obtained from the server of the Howrah court. CA.
No. The resolution taken by the Bar Association.
That I have not checked up. But the order record as
This
per
check
the,
and then come. These are exempted. Filing of plaint.
no, my lord, I am not on that.
Plaint, filing of written
I am
statement.
not on even that. Now, my lord, what happened, my lord? On 9th of June, I did not take steps. My lord, I agree. My lord, on 25th, next date was fixed. My lord, court show caused me. My lord, in the show cause, I said that it's a difficult or, my lord, mistake on the part of the lawyer. He was of the view that 9th of June, my lord, is the date fixed for filing of amended plaint. So he missed the date of 14 days period as per statute or the code. Now, my lord, this explanation was given in the show cause. By the impugned order, court proceeds the impugned order in a manner that is mandatory. Court is now powerless to extend the time.
Where is that observation?
My lord, kindly sees the impugned order that is of that tenure. If my
So
lord
where
sees,
is that the court? Court
Lord,
also does not have the
my
power.
lord,
where is
from
that?
the bottom, 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 10 line stop, I find there is not a single reason why plaintiff did not file the amended plaint within 14 days of allowing the amended petition. My lord, the power of the court has not been discussed. 14 days over, and my lord, that's it. My lord, CPC says such extended time court may grant.
You will create all these problems. I think these are to be rejected. Then the timelines can be adhered to. Otherwise not.
My lord, I was on the,
You have to start rejecting this type of.
I was just, my lord, on 35, 40 days, my lord, after the date, my lord, I filed it.
35, 40 days.
My lord, because the date fixed by the court, I appeared and I filed on that end. By that time, my lord, 14 days was over. My lord, Rule 18 says, if a party who has obtained an order for leave to amend does not amend accordingly within the time limited for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order, he shall not be permitted to amend after expiration of such limited time as aforesaid or of such 14 days as the case may be, unless time is extended by the. So, my lord, power of extension is there, my lord. It's not that mandatory, my lord.
148 is also there.
148 is also there.
one.
For the petitioner. The opposite party number 3, before the learned consumer commission, is a petitioner before your lordship. This is a case arising out of a dispute between the intending purchaser and the developer. The developer is the opposite party number 1. I am only a witness and I am the opposite party number 3. The developer had
witness to what?
Witness to the agreement between the parties. I'm only the witness. And the opposite party number 1 had made an undertaking that he'll for a one-time settlement that he'll pay rupees 40 lakhs. There was certain he couldn't meet up with the time limit that he said. Now what the learned commission has done, I am a employee of the central government. My employer has been sent with an order to initiate proceedings against me, and I have superannuated, my salary and pension has been stopped. But you kindly takes up the impugned order. Well, kindly takes up the second paragraph.
That is a different thing.
Considering the conduct of
it does not say for attachment of salary. Impugned order does not say so.
But it says that considering the conduct of the OP, it is necessary to inform the controlling authority of OP number 3, Madhav Saha, an employee of Textile Committee, of the pendency of the matter. Request him to take any step permitted by the government of India rules.
A different thing.
So, my lord, I am neither connected with this dispute in any matter whatsoever. My employer has been sent such a letter, such an order. Based on this, I am not getting my salary, and also I have superannuated.
Why are you being implicated as opposite party number 2?
I was a
Where is
witness.
the complaint?
I was a witness. Kindly takes up. And there is no order itself. It was an undertaking during pendency of the proceeding. It's a page number 12.
Party.
Page number 12.
Why the witness was made a party?
Here I am the opposite party number 2.
You are the opposite party number 2.
2, Madhav Saha.
And who is the developer?
Developer is the opposite party number 1, Bashanti Enterprise. In paragraph number 2.
That's been done rightly.
Paragraph number 2 and 3, it has been.
Rightly, it has been done. Rightly. You are saying opposite party number 1 and 2. What is the relation between opposite party number 1 and 2?
But I understand that. But in any case, this order couldn't have been passed because I am paying the 40 lakhs out of 40
First pay.
36 lakhs has been paid. 36 lakh already has been
What is the
paid.
balance remaining?
4 lakhs are remaining.
When we will pay?
As lordship desires.
Pay it first. Attachment will go.
And also I am not receiving the salary. That's the difficulty.
You will not receive. Please first pay. You will receive everything.
And now the difficulty is that when
you will pay,
they're computing compound interest.
When the amount of 4 lakhs will be paid.
Lordship, my instruction is that after this civil revision was filed, 1 lakh has been paid, so it is now 37. 3 lakhs is outstanding. So lordship kindly keeps it tomorrow. I'll take instruction. Now compound interest is being levied regularly, and that is why the sum is
has to be. Rightly it was done.
Lordship, but here the opposite party number 1 is the developer.
I know that.
And the 2 isn't.
Now the money is coming. From whatever end, it is now coming.
But 40 lakhs was settled. The amount 37 has already been paid.
Balance 3 lakhs is nothing. Maybe not nothing to your client, but it is something for the complainant.
Actually, I am paying the amount, but the difficulty is that compound interest is being calculated.
have appeared.
No, the difficulty is the court is proceeding in a regular manner, not in the manner which how the order 37 suit should be proceeded with. Far less, my lord, a commercial court act. Now, my lord, kindly see,
Mr. Kormakar, there are two ways. I can direct you to serve. If they come, it will delay. Or I can direct this application. You have taken the outer application that their right to defend goes.
Lord, kindly comes to
According
131.
to you, their right to defend goes.
Lord, kindly comes to 131. 130, page 130.
130, yes.
130. This is the other mode of service. Rather, it starts from 29. 129. The Lordship sees item delivered to addressee. Item delivered to addressee.
Mr. Kormakar, but I cannot say from here because the court records that has fixed a date for service of summons. Might be there was some irregularity in service.
It calls for the record.
Mr. Kormakar, that will delay. Otherwise,
Lord, when this matter came up, when I first moved this matter, Lord, before Justice Basu Chaudhary, Lord, my Lord was of the same opinion that the court will proceed. Lord, January went, February went. Now, the next date is in April. Lord, the court is proceeding as if, Lord, it is a regular suit. On the first day, within 10 days from the date of service of summons.
no, where is your application? This IA, the IA which you have filed?
Not the application, your Lord.
2 of 2024, where is that? Have you annexed that?
Yes.
Or do you have a copy of that?
135. Kindly comes to 135.
Yes. So this is your, I'm directing this application to be disposed of. So you have prayed for a judgment in accordance with this order 37 rule 36.
Rule 36 and read with Lord rule 23 also. Lord, that should be there, whatever is there.
So I'm directing this application to be disposed of.
Lord, I'm skeptical, but again the same thing will happen. Lord, from September till Lord, next date is April. Already 6-7 months gone.
3 days left for April, Mr. Kormakar.
6-7 months gone.
Only 2-3 days left for April, and there are 5-6 holidays in April. And immediately after that, 22nd, it has
Lord,
been
it will be easier. It will be easier.
2 days, my lord, then 9 days.
It will be easier. It will be easier if a lordship calls for the record and passes a decree herein. So this is an admission.
Divisional court should be slow in doing that.
This is order 37, Lord.
Maybe.
And that also in commercial suit.
Maybe, but the decree is to be passed by the trial court, not by the revision.
Yes, but if the formalities are complete, only the decree is to be passed.
Has to see only
Lord,
whether
I
the
bow down to what
procedures
your
are.
lordship is saying, Lord. But this is not the way, Lord, suits are conducted in order 37. Lord, kindly see, I've handed over, Lord, one after the other order.
Once come for the defendant in a commercial suit. Ashun. This application
And suit for declaration, permanent injunction and recovery of possession.
Suit for declaration of title.
Title, permanent injunction and recovery of possession. Now, my lord, I am the successor of the defendant.
What is the impugned order?
The order of 41 Rule 5 was rejected.
Order 41 Rule 5 stay.
Stay.
Stay of what?
Stay of execution case. I against that degree against
Degree passed.
Degree passed.
Degree for recovery of possession.
Degree for recovery of possession. And that was put into execution. I papered this appeal against that degree. And that appeal is pending. I made an application under order 41 Rule 5. But till that appeal disposed of, let the stay be there.
Execution be stayed. What happened?
That was rejected.
Why?
Kindly see this order.
What is the ground?
Kindly see this order. Order dated 4th October 2024.
What is the stage of the appeal? Appeal of 2018.
Yes, sir. 30 November 2004, yes, sir.
Your Lordship will recall, my lord, there are two analog. On last occasion, my lord, on Friday, probably.
64 and 65, yes.
Yes, my lord, 60, this is that matter, my lord. I am challenging the order of the National Commission, my lord, where I am representing the hotel owners, my lord. Fire broke out, my lord. The Lordship wanted to see some documents as regards to at the relevant point of time what steps the hotel owners were taken, whether the fire extinguishers were in order or not. My lord, I have found the forensic report is there in the record, but so far the periodical reports are concerned, my lord, I have brought through WhatsApp, my lord, I have brought documents.
You want to file a supplementary affidavit?
Yes, my lord, I am required to. I am required
As
to
paid
input the
for
matter.
by the learned advocate for the petitioner, leave is granted to the petitioner. Both
64 and 65.
64 and 65.
Yes.
Separate orders, same order. Yes, next. 66.
This is my application, my lord.
Yes.
This is an application, my lord, for non-compliance of the order passed by this honorable court, my lord. In earlier civil revision application, my lord, that is annexure A, my lord. It starts from, my lord, page 9, my lord. And the relevant part is, my lord, at page 15, my lord. There was a specific direction, my lord, to dispose of this suit, my lord, this suit of 2008, my lord. To dispose of
contempt. Contempt.
My lord, like this. So, my lord, I am seeking, my lord, only, my lord, extend that period, my lord.
You has been transferred.
Thereafter, my lord,
It's very difficult to pass a direction for expeditious hearing.
thereafter, my lord, PO has joined, my lord. PO has joined, my lord, 30th April.
So if it is the fallout of a direction for expeditious hearing, I think this type of order should not be passed henceforth.
My lord, PO has joined, my lord, thereafter. In spite of that, after joining, my lord, the order was passed, my lord, hearing on, my lord, 13 January 2025. Thereafter, my lord, 6 February. Now, today is the date fixed, my lord, no order, my lord. My lord, it's a 2008 suit, my lord. Kindly appreciate that, my lord. And the defendant is, my lord, 80 years old, my lord. Well,
it's now at the stage of order 670.
No, my lord, that is the difficulty, my lord. They are dragging the suit, my lord, because it was fixed, my lord. When the suit was dismissed, my lord, it was fixed for peremptory hearing, my lord. And they are failed to give any evidence, my lord. Thereafter, on 3 occasions, they have given chance, my lord, but they did not lead any evidence, my lord. And show cause order was passed, my lord. They failed to give any show cause satisfactory, my lord.
There is a date has been fixed for hearing of order 617.
Yes, my lord. Thereafter, they may
617 by the plaintiff.
Plaintiff, my lord.
Yes.
But order 6, it is already heard, my lord. On 2 occasions.
When it was heard?
It was heard on, my lord, 13 January, my lord.
13 January of which year?
This year, my lord.
Yes. So what is the order passed?
No order passed.
No order passed.
No order passed, my lord.
If it is allowed, you have to challenge that. Or you don't want to challenge that?
I don't want to challenge that, my lord. If it is allowed, I will file my written statement and my lord.
I will record your submission to that.
I do not know whether order is in my favor or not, my lord. If it is in my
record that, if it is against you also, you will not challenge. That is your submission. And when you challenge, you will say, please stay the proceedings. Nobody knows how many civil division applications were filed starting from the initiation till this date, and how many stay orders were passed.
No stay order passed, my, because they preferred civil division applicant two occasions, my lord. That is dismissed, my lord.
Yes, it was adjourned on 19th of June 2024. Resolution of Bar Association.
Resolution of Bar Association.
You filed a contempt application against the Bar Association.
No, I am not.
This you are alleging violation of the order of the court.
But
court is. We will make arguments. This application under Article 227.
Petitioner is not taking stays on regular basis.
No, defendant.
But defendant only on occasions.
No, 3 occasions. I've recorded that. That is why. All the orders I have recorded, that is only the orders which have annexed. There may be other orders.
No, I have all the orders.
Maybe, sir. Yes, next.
I appear for the petitioner. Let her do it.
I appear for the
And I am
opposite party.
sitting beside her. Let her.
Yes.
He's more.
I appear for the opposite party.
Lordship, I am for the petitioner, Lordship, defendant, judgment debtor. Is the petitioner before your Lordship? Lordship, initially a suit for specific performance was filed.
Impugned order.
Lordship, there are two orders. Now, Lordship, the first order, the impugned order, Lordship, has not been stitched. I have it with me. Lordship, kindly. Yes.
20th July.
This,
What is the order? What is the impugned order?
here, Lordship,
What is the
my
date of the order?
November 2024.
first order is 20th of July 2024.
16 November is there, certified copy.
No, 20th July, Lordship. I have.
November is a recalling.
Yes.
20th challenge police.
Yes. In the Lordship kindly sees in the prayer portion, it has been mentioned. But wrongly, Lordship, in the preamble portion, it was not mentioned as
20th July and 16th of November.
Yes,
Both
yes.
the orders we have challenged.
Yes, but Lordship,
So
the
this is 16th of July.
Yes. 20th of July, Lordship.
Sorry, 20th of July. Yes.
Lordship, in this order, Lordship, my learned advocate, Lordship, gave an undertaking. But Lordship, to produce certain document, an agreement, Lordship. But Lordship, there was no instruction on our part to give such undertaking, Lordship. And since
What is the impugned order? Occupation charges.
Yes. No, what happened, Lordship, initially? 8,000.
Charges.
Yes. Lordship, they obtained a decree for specific performance in respect of 100 square feet.
Specific performance.
Yes.
Yes.
Now, what happened, Lordship? I have filed, Lordship, an Order 9 Rule 13. It was an ex parte decree, Lordship. Initially, I appeared, thereafter did not contest. Now, my Order 9 Rule 13 is pending. In the meantime, they have levied execution. In the execution case, Lordship, initially on contest, 8,000 rupees was passed. Subsequently, they have filed a modification application saying
Why
that
occupation charges is a specific performance? Because you are given possession.
Yes.
What performance?
Third party right has been created.
Yes, Lordship, we rented.
Please take your seat. Is there a chair behind you?
No.
Do not have any chair. Please give him a chair. Yes.
Now, their case is that, Lordship, that I have given rent to Med Plus in respect of 500 square feet of the premises. And their case is that from Med Plus, for giving rent of 500 square feet, I am getting 35,000, Lordship. So, Lordship, they filed a modification application claiming that 40,000 rupees, Lordship. And by first order, Lordship, my learned advocate, without our instruction, Lordship, gave an undertaking that he will produce the rent agreement on the next day. I have challenged that order. And on the next day, Lordship, since we did not...
Your advocate gave an undertaking.
Yes. Wrongly. But we did not have any instruction. I have filed an application for recalling of that order. By the next order, Lordship, those applications were rejected.
The advocate heard.
No.
Then
Lordship kindly directs
some
that.
allegations against the advocate.
Fine,
The
Lordship,
advocate was not.
kindly directs the learned executing court to hear the learned advocate.
What has been done? It was
35,000 has been directed to enhanced.
তারিখের অবেদটা পড়ো না 16 তারিখ
Lordship, first kindly sees order dated 20th of July
Why
24.
Contempt of Courts Act, Section 12?
Because, Lordship, there was an order of injunction. They said that we have violated.
In violation of that.
Yes, I have given Lordship rent.
Fight between brothers,
Brothers.
Brother and sister. Sister, sister.
brother and sister.
Yes.
Two brothers, one sister. আরে দাদা ভাই তো আমার সাথে আরে
No, what happened to the Order 9, Rule 13?
That is pending, Lordship.
What is the stage of Order 9, Rule 13?
Evidence, Lordship, I'm told.
So, 20th of July 2024.
Yes, Lordship.
And what happened in 16th of November?
Lordship, I filed 3 applications, one for recalling of this order, Lordship, citing that we did not give any instruction to give this undertaking. Another application for section 5 and another petition.
5 of what? 151, because that was beyond 30 days.
Yes.
And
And another, Lordship, for depositing the arrears for 8,000 rupees.
at the rate of 8,000 rupees.
Yes. And by this order, Lordship,
You have the agreement. You have produced the agreement.
no.
Why?
I have it with me, Lordship.
Why you did not produce before the learned court below?
এখানে অ্যাপার্টমেন্ট করছি যে আমি 57,000 টাকা পাচ্ছি
That was there was a direction upon you to produce the agreement. Because
Lordship,
your case was
no, that direction, he undertook, Lordship, that
Yes.
it will be provided. But
Yes.
Lordship gave any instruction.
maybe, but your case is that you have let out pursuant to an agreement.
Yes.
Why are you withholding that agreement? This shows there is
If you
something in the agreement.
No. If your Lordship so desires, I can produce it here.
So he only, the advocate, only undertook to produce the agreement. What is the wrong in that?
No, he also, Lordship, undertook to say that I am getting 12,000 rupees per month.
which is incorrect.
You are,
I am getting 12,000 rupees per month.
what is as per the agreement? Where is the agreement?
57,000
57,000.
আমি তো লিখেছি পিটিশনে লিখেছি
Yes, because Lordship
Square
kindly
feet.
sees 500 square feet, 57,000. His claim is over 100 square feet. So at best, he can claim 1/5.
His claim is,
Over 100 square feet. The decree is in respect of 100 square feet.
his claim was
no, this 500 is the shop room.
Yes.
So where is your agreement for sale?
Agreement-
How can it be portion of a shop room?
Lordship.
Where is that?
তোর কাছে এগ্রিমেন্টটা আছে যেটা স্পেসিফিক পারফরম্যান্স আছে?
I'm taking Lordship. 29. She's
Name will not be recorded.
I leave it to you, Lordship. And it is my pleasure and privilege, occasion to assist her.
সত্যি
Yes. Where is the agreement?
Lordship.
You have a copy of the, you have got the agreement.
The agreement was between me, the first agreement,
No,
initial agreement.
বোনের সাথে এগ্রিমেন্ট
No. Where she has let out. Her client has let out.
Was never produced in the court below.
Yes, now that was not produced. No, this is the agreement for sale.
Yes. Lordship, these. তিনটে কেন? ও লর্ডশিপ দাদা একটা কপি যশাপে দিন, ওটা এক্সট্রা, ওটা তিনটে। একটা যশাপে দিন, বাকিগুলো কেন দেবো তোকে? তুই তো সব করে এনেছিস।
This is the lease deed.
Yes, Lordship. এটা কি দিলে? এটা কি? হোয়াট ইজ দিস? এরকম ভাগ ভাগ করে? এটা কি এটা? না যেটা মেড প্লাসের সাথে করলাম দুখানা।
No, this is with some other optimal health.
Yes.
I think this is not the one.
এটাই তো, এটাই মেড প্লাস তো। লর্ডশিপ, দে আর মেড প্লাস।
They are made plus.
Yes. Lordship, kindly see
The
paragraph
shop room-
5.
Shop room
Yes, Lordship.
It's the same. Measurement, I do not know how this measurement can differ.
Lordship will kindly see my the decree, Lordship.
No, let me see.
আমরা যখন ডিগ্রি তখন কি বাড়িটা বানানো হয়েছিল?
How many shop rooms are there? 4 shop rooms. So how can these two differ? Measurement?
No, Lordship, what happened? I did not get sanction in respect of 100 square feet, according to the sanction plan, Lordship.
Yes.
That is why, Lordship, his claim, I made an agreement with her regarding 100 square feet. And when
It's one room. How can it be demarcated as 100 square feet? That is what I fail to understand.
Because, Lordship,
Because everywhere in your agreement, it's also one room.
yes,
In their agreement for sale, it's also one room.
yes.
But only the measurement is changing and the other things remaining the same. How can this
Because,
measurement?
Lordship, today we say it is our case is that, Lordship, this decree is not executable since, Lordship, that portion is not identifiable.
That is a different thing altogether. But
There is no 100 square feet shop room, Lordship, in the ground floor of the building.
so if it is, even if you accept your argument that it is 100 square feet,
Yes.
so 1/5.
Yes.
So
That means
1/5 comes to how much?
Around 11,000.
You are not agreeable to take 11,000.
Two things, sir. Just I wasn't clear. The suit was filed in 2014. He initially entered appearance in the suit. Thereafter, the sanction plan, which they are now denying, which was filed, obtained in 2015, subsequent to the suit, there has made provision of the shop room. They did not appear in the suit. Initial after appearance, they disappeared. Decree was passed.
Disappeared.
Yes, the decree was passed.
Now they are here.
No. Thereafter, we filed execution proceeding. In the meantime, they created third-party right. We filed an application for injunction.
Third party rights means leasing out that property.
We have filed application for injunction. They challenged that injunction in this appeal also. Appellate court did not interfere. We have filed a contempt application. My proposition is that we have obtained a decree with regard to 100 square feet. I cannot enjoy the usufructs of the decree because they have intentionally, after knowing up to the known of the decree, created third party right. Now they are entirely obtaining that portion. Trial court in
The only thing is that they have filed an application under Order 9 Rule 30. That is to be disposed of. So you want the property or you want the occupation charges?
So
if you want the property, but there is a dispute. Your claim is with regard to 100 square feet. So even if this is accepted, you are not disputing this lease deed. You are also.
I have not seen, madam.
You have not seen.
This deed was 5 times opportunity was given to them. Each and every time they did not produce a copy. The court was of the opinion.
So I can do one thing. I can give them liberty to produce this. The learned executing court shall decide after.
Deposit this amount, 35,000. That should not.
35,000, Lordship, it cannot be.
What is the amount? 8,000 also.
8,000.
You have also not deposited.
We have paid. Thereafter, we have not. Because this order was passed.
Initially, 8,000 was there. We said that they are getting 40,000 in my application. because we did not know what amount they
Yes,
can
yes.
get.
Now, Mr. Bhattacharjee, this application they will produce. So what is the amount due from August, September?
No, from August, Lordship, this.
From August there is due.
Yes,
August, September, October, November, December, January, February, March.
August.
8 months.
8 months, Lordship.
So it's 40,000.
Yes.
So deposit something more
So they are
with
getting
regard to that.
57,500. They are getting 57,500 with admin.
That is they are saying 500 square feet.
Yes.
So there is a dispute with regard to the area. If it is also on the square feet, according to their case, it's 11,000. So from this, at the time FSC appears, so I'm directing them to deposit a consolidated amount. I'm directing this application to be heard afresh after giving the copy of the agreement.
Lordship, let us then deposit 40,000.
I'm not fixing any amount rate that will be decided
Yes,
by
yes.
the court. So I will put a consolidated figure that they will have to deposit. So it's 40,000. And if it is 11, according to you, it's
But Lordship, if I now pay,
if you consolidate
it, Lordship, let me put Lordship at the rate 8,000. Let the
from
execute.
your document, it is 11,000.
Then
It is
Lordship,
coming.
Lordship,
I'm not fixing on a. I've calculated 11,000.
then Lordship 11,000 is also automatically
I'm not
fixed.
Eight months. So you deposit 80,000.
8 months, okay.
So 12 months is due. 12 months is due. Only
12.
Yes.
No.
12
From August,
only
Lordship,
12
my instruction
only
is
12 months
August.
Even 12 months is due. It's my instruction.
All right. I'm not saying with regard to the areas. I'm directing them to deposit a consolidated amount. All right. Everything sash out there. What is the amount of default?
They in my account. I
But Lordship, there was a specific
So
direction
what was the direction here?
to give their account number.
I-
Till
I-
date, they have not given.
We have some. My instruction
No.
that has been given.
No. My Lordship advocate on record, he's also appearing in the executing court. He said he has not received.
My
What is
advocate
it?
record says that I have not appeared. If whatever the course of the day, I will give the account again.
Lordship.
Fixed matter আছে তো।
Lordship, we have also given them the lease deed. Lordship kindly records it.
You have given, I think Mr. Bhattacharya will not dispute that. Between the members of the profession, you are giving, he will deny. All things cannot be recorded. Yes, yes.
Supplementary list, item number 1.
Get for them.
Who is for the petitioner?
My lord, I'm for the.
Yes, where is Mr. Banerjee?
But he has been notified. He has been notified, notice has been given.
Who has been notified?
Mr. Gansman, I am appealing as junior.
Complainant has been notified.
Complaint, my lord, pursuant to your lordship's direction, my lord, yesterday they are added as respondents, all the parties.
You have served.
All them have been served.
Received.
7 except
State
complaint.
is still there or it has been
No,
demolished?
complaint does not reside there.
Maybe. May not.
Now he is residing at Mumbai. And one, my lord, lady, my lord.
State is still there or it has been demolished? State is still there or you are.
I don't know. I have no instruction because
It has not yet been demolished, my lord.
It has not been demolished. Don't demolish that for some time.
Due to non-availability of demolition squad, my lord, that is today, my lord, what cannot be done.
When the demolition squad will be available? Next.
I have asked the engineer, my lord, they are trying to.
Well, only a chance of hearing. Well, only a chance of because complainant we have served by registered post. Because one lady, my lord, refused to accept.
Person responsible is the husband.
Yes, my lord.
And the petitioner is the wife.
No.
Very noble way of moving a writ petition.
My lord, they have not been, my lord, they did not represent.
And they are saying.
They did not represent, my lord.
Matrimonial proceeding is pending between the person responsible and the.
No, my lord, no. My lord, the original promoter, my lord.
Chakravarti, don't open your mouth too wide.
Sir, I have no idea.
Yes. You don't have an idea.
Sir,
Don't have an idea. You have filed a writ petition, you are moving the case. You do not have an idea with regard to the relation. And I have only heard for 2 minutes. I know what is the relation.
No, but there is no matrimonial
There will be. Now, I was asking you.
No.
I was anticipating that he will say, yes, the wife did not knew about this, was not aware of the notice. Husband is the person responsible.
He has not received. He has not received. My lord, I have asked.
They do not.
I have asked the petitioner. I have asked the petitioner, my lord. They have not received. They did not, my lord, attend.
Petitioner will not receive.
No,
Petitioner is the.
her husband also, they did not receive. my
But
lord.
he did not come. How did you inquire from the husband? He is not a party.
No, he is the party. He is the party for people.
No, husband also came before you.
Corporation.
Husband also came before you.
No. Petitioner asked, my lord.
Yes, petitioner's husband.
Petitioner
Is the person responsible.
Person responsible.
He came before you.
He has nothing.
But you have advised the wife to file a writ petition.
My lord, it is the name of the, my lord.
Mr. Chakravarti, don't open your mouth too wide.
May I submit one thing, my lord? One thing, my lord. Property purchased by the petitioner.
Maybe.
So, my lord,
Maybe husband made an illegal construction. That illegal
not at
construction
all
is being
connected.
purchased by the wife.
No, my lord, husband is not at all connected. The promoters are connected. Husband is not at all connected.
Husband has been included as a person responsible. Kindly come to page 99. Person responsible. Last person is Tapas.
Corporation has done, but my husband has nothing to do with this matter. My lord, kindly have a look to the, my lord, deed, my lord. Who are the owners? My lord, kindly have a look, my lord, who are the promoters?
Before the.
Who are the promoters? No.
Already they that date, the petitioner shall
No, I cannot, could not file the affidavit service because of the, today it has been, registered, posted.
you have posted today.
Because yesterday it was not.
What
Ye-
type of things are
Chakraborty,
going
what are
on?
you doing? Why you could not post yesterday?
Because
In the evening yesterday it was,
Evening, do you know how long the GPO is open for speed post?
Ask hand service was went to the premises, madam.
it is
Don't
not,
take all this plea.
it is not possible also to.
No. One lady has refused to,
You know that I have kept it for today and you are posting it for today and you are saying they are residing in Mumbai and Chennai.
We do not know, only one lady, sorry, madam.
Yes, fixed matter আছে 415.
Really, my lord, one thing, a downloaded copy may be available today at least. I can.
Downloaded copy of what? You have not got yesterday?
Yes.
So
Yeah, always, because I have asked, I have,
why are you apprehending that today you will not get?
yesterday I prayed, I have got it.
Grateful.
Yes. Call the fixed matter. 4 p.m. টা ডাকুন আগে। Oh, Passover. Yes, have you inquired? I can take up.
Pinku Pathak is for the plaintiff.
I can take up this matter.
Devashish Bhattacharya for the defendant.
Devashish Bhattacharya.
Not Chakur.
Lordship, Debashish Bhattacharya, Mr. Debashish Bhattacharya was till the impugn order was passed, he was in the recorded advocate. Then the brief has been changed and Mr. Parikshit Basu is appearing in this matter since the impugn order.
I can take up, Mr. Mahato. On your assurance, I am taking up. Yes, ask. This application under Article 227. Why are you scratching your head, Mr. De? Yes, Mr. Chatterjee.
Mode 1.
Can be taken up. Chatterjee, this is the difficulty. 31st of let me see what can be done in April. Let me see what is the position of the list in April.
Now it is what to me. I cannot properly oppose that.
Why? Let me see in the April what can be done. Mr. Chatterjee, these are all upgraded motions. This was mentioned. If you please, I request you to come tomorrow at 10:30. Tomorrow, kalke budbar to. Mr. Chatterjee, I am requesting you with folded hands. Please come at 10:30 tomorrow in the morning.
May I seek your lordship's indulgence once?
I appreciate.
Is coming and promise to undertaking. Is the I do? That is the whole drug.
Yes. Let me see what happens in April. I will do something. I will consider because let me see. I think till 11th that circuit is. I don't think after that. Then you will enjoy that Poila Boishak and other things.
Practice it. Please, summer vacation. In 2 days, I said in Calcutta.
So 15th is holiday. You are in difficulty. I think most of you will be in difficulty on 16th and 17th. That is a different thing. I think most of you will be in difficulty on 16th and 17th. Ask your advocate on record to mention. I will consider that if it is taken up. Yes, Mr. De. Mention tomorrow. Nothing will happen.
Liberty to mention today because tomorrow is the date for current post and these matters were appearing at 95, 96, 97.
Today?
Today, today's case.
Yes.
So if your lordship kindly takes up the matter any day subject to your lordship's convenience because these matters were harder out and your lordship intended to file an interim order but an advocate acted without any caveat.
95 and 96.
96, 97.
All right. I will consider this. Please come tomorrow. Let me see what happens.
May I have lordship's kind indulgence?
May your lordship.
Yes, Mr. Chatterjee.
Item 82, my lords. Your lordship.
Mr. Chatterjee, I have proceeded to some extent today.
My lords, actually, day after the matter, I think, is coming up. So
Please see, I will take. Today we have completed up to 67.
My lords.
I think it's not very far off.
My lords, if
be reached by tomorrow.
My lords, in case it doesn't happen, then I will be in difficulty. All I was praying, my lords, may give me a little time, if possible, at 3 o'clock. Subject to your lordship, I don't know, my lord.
Yes, let me see what happens.
One thing, my lord, due to communication between me and my junior, my lord, yesterday 3 matters were there. I am not asking for enlistment of 3 matters. Now, my lord, your lordship was pleased to adjourn this matter for the day. It is the impression that the matter will. Well, out of 3, my lord, I am praying 1 is very urgent, my lord. It has been communicated that yes, tomorrow matter the hearing was continuing.
I've said hearing any prayer for adjournment, I am granting. But
it is
you have got a chance Others
My
are
lord,
taking an action.
that is why, my lord,
That is why I'm following this. If you
the
want
three-man
me
suit
to
that I was
revert back,
asking-
I will, from every day, I will call from item number 1.
only one thing, my lord, there is,
Choice is yours.
I bow down to your lordship, my lord.
You have got an opportunity, you did not avail of that.
It is, I am on legs, my lord, it is informed.
Left, Mr. Rai. It's difficult to bring it back. You have to avail the next.
That is, it is so urgent, my lord. 3 minutes are there, I am not asking for all, only one matter, injunction, my lord. Refused. On the ground, the partition suit, a co-sharer is entitled to 2 decibel. He cannot ask for
Let
adjustment.
me see, come tomorrow, mention thereafter.
My lord, item number 80, my lord. If it is brought within 50, then I think it will be completed. My lord,
Within
it is a
50.
matrimonial suit is
Within
pending at
50. I think your matter will come within 50 tomorrow. Because today I have reached up to 67.
My matter 83, would you lordship take up the
80?
83, last.
Yes, 82 has been mentioned, 80 has been mentioned, 83 has been mentioned. If I upgrade all these, same thing.
Only application.
Sure.
সাইডটা দেবেন একটু